Good morning. Welcome to the Sunday History Rewind. I'm Jim Lumley. We've been talking recently about the United States Constitution, which I refer to as the greatest governing document ever devised by humankind. The U.S. Constitution in Article 3 sets up the Supreme Court and the lower courts. The President of the United States gets to nominate justices, but they have to be approved by the legislature, or at least the upper chamber, the United States Senate. In 1937, President Franklin D. Roosevelt made an attempt to pack the Supreme Court by proposing 4 additional members. Roosevelt wanted to do this because the Supreme Court was striking down many of his New Deal initiatives. By doing this, the president showed an incredible lack of deference to the separation of powers enumerated in the Constitution, a philosophy that was propagated by Montesquieu and John Locke. Today on the Sunday History Rewind, we're going to talk about the history of the United States Supreme Court.
In 1937, President Roosevelt had a problem. A majority on the Supreme Court, led by these guys, the conservative wing known as the Four Horsemen, had spent the previous years striking down many of the laws passed as part of Roosevelt's New Deal. So FDR decided his next reform would be the court itself.
For each justice over the age of 70, and there were, I think, 6 of them at the time, he would add a new justice to the court. So that meant he was going to massively transform the court and put on loyalists to him.
Congress overwhelmingly voted down his proposal, and no president has tried to increase the number of justices on the court since. But what does the Constitution say? When drafting the Constitution, the framers knew the new country needed a Supreme Court to weigh in on legal challenges to the nation's laws. But they didn't know exactly to what extent it would provide a constitutional check on Congress and the executive branch. In fact, it wasn't until 1803, in Marbury versus Madison, that the court first ruled a government action unconstitutional, officially establishing the act of judicial review. So in the beginning, the framers kept the details about what the court should look like pretty vague. Article 2 of the Constitution gives the president the power to nominate a justice and the Senate the ability to confirm him or her. And Article 3, which establishes the judiciary, says only that justices hold their offices during good behavior. We'll get back to what this means later. And that they get a salary that can't be diminished. That's it. They left all the other details up to Congress.
The size of the Supreme Court is actually up to Congress to specify by law. That actual number is not in the Constitution.
Noah Feldman literally wrote the book that law students use to learn constitutional law. He says the framers wanted to give Congress the flexibility to shape the court in response to the needs of a growing nation.
The Judiciary Act of 1789, one of the first important laws that was passed, specified the size of the Supreme Court, and they actually started with 6 justices at the time.
From nearly the beginning, politics played a role in shaping the size of the court. During his lame duck session, President John Adams signed a law bringing the court down to 5 justices. The following year, Thomas Jefferson, who felt the move was an attempt to limit his power, signed legislation to reverse Adams's law before it could go into effect. Over the next 60 years, Congress largely tied the number of justices on the Supreme Court to the number of circuit courts in the rapidly growing country. In 1863, with the creation of the 10th Circuit, the court got its 10th justice. But in the wake of Abraham Lincoln's assassination, Congress trimmed the court to 7 justices to prevent President Andrew Johnson from loading it with Southern Democrats. A few years later, the new Republican president, Ulysses S. Grant, set the number back to 9 under the Judiciary Act of 1869. That's where things stood until FDR.
But we cannot yield our constitutional destiny to the personal judgment of a few men who, being fearful of the future, would deny us the necessary means of dealing with the present.
FDR's court packing plan ran into 2 major problems. The first was that the sitting justices, including moderate and liberal justices, were deeply opposed to it because they thought it would delegitimate the institution. The second is that lots of Democrats, especially in the Senate, were sensitive to the charge that Roosevelt was basically trying to make himself a dictator. The Democrats already controlled the House and the Senate, and they controlled the presidency. And if they also controlled the Supreme Court, there would be no check on his power at all.
I shall not be a party to breaking down the checks and balances of the Constitution.
This is more power than a good man should want or a bad man should have.